My name's Wendy Lacey. I'm the Dean of Law here at the University of South Australia, and I'd like to acknowledge that tonight's event is actually a co-sponsored event between the School of Law and the Bob Hawke Prime Ministerial Centre. Unfortunately, the Executive Director of the Hawke Centre, Jacinta Thompson, is unwell and sends her apologies, but on behalf of both of us, I'd just like to welcome you all. Tonight we are obviously meeting on the traditional lands of the Kaurna people, and I'd like to pay my respects to them, including their elders, both past and present. There are some VIPs in the audience that I'd like to acknowledge and make welcome. First, the Honourable Tammy Franks, Member of Legislative Council, our Speaker and Patron of the Hawke Centre, the Honourable Michael Kirby, Adjunct Professor of Law Ivan Shearer, and Anne Gale, Commissioner for Equal Opportunity here in South Australia. The fundamental themes of the Hawke Centre are strengthening our democracy, valuing our diversity and building our future. The Centre aims to honour these themes through providing accessible and thought-provoking programs that engage with our diverse South Australian community. On the wall of the newly named Ivan Shearer Moot Court, just named today in the School of Law, are the words taken from Article 7 of the Universal Declaration of Human Rights. Those words are that all are equal before the law and are entitled without any discrimination to equal protection of the law. Now, equality, freedom from discrimination, democracy and valuing our diversity are themes which are not ordinarily associated with North Korea. Yet every North Korean is entitled to the same human rights that we all enjoy here in Australia. However, we know that systematic, widespread and grave violations of human rights are taking place in North Korea, a disturbing fact that provided the impetus for a 2013 United Nations Commission of Inquiry into human rights violations in the DPRK. Today we have the honour of hearing from one of the members of that Commission of Inquiry, one of Australia's most eminent jurists and former High Court Judge, the Honourable Michael Kirby. Now, Michael really needs no introduction. We know him not only for his remarkable intellect and decades of public service as a judge, advocate and legal reformer, but equally for his compassion, his generosity and his unfailing commitment to justice. It is always an honour to hear Michael speak. In terms of housekeeping, this session will be available as a podcast, both on the Hawke Centre's website and the School of Law's website afterwards. We encourage you to bring this to the attention of any friends or colleagues who may have been unable to be here this evening. To avoid interruptions, can I ask you that please switch your phones to silent, but you can participate in a Twitter conversation using the hashtag KirbyUniSA. Michael will take questions at the end of his formal presentation, but I'd like to ask that you keep them short so that we can have as many questions as possible without running over time. Michael has a plane to catch, so we have a car waiting for him as soon as the lecture is over. So I'm sorry there won't be any photo ops at the end of the lecture. It now gives me great pleasure to invite the Honourable Michael Kirby to the podium. Please join me in making him welcome.
Thank you very much, Dean Lacey, for having me here. I also honour the Kaurna people. I reflect on the wrongs that were done to the Indigenous people of our country and on our duty, particularly of lawyers, to right those wrongs and with citizens to make Australia a better and kinder place. It's very moving to me as the former chair of the Commission of Inquiry on the Democratic People's Republic of Korea, North Korea, to come here in Adelaide to see such a large audience of citizens who are sufficiently concerned and interested in the issues of the Commission of Inquiry to come along tonight. And I intend to do two things. First, I'm going to give you a brief resume of the matters that were dealt with in our report. And second, I'm going to address myself to a particular issue, which is the issue of how the legal tradition, which is taught at UniSA, the University of Adelaide, Flinders University, the tradition of the common law of England, affected the way in which, exceptionally, the Commission of Inquiry on North Korea performed its work. And I think that will be an interesting and special issue in this talk because methodology matters. The English in their legal system were always very concerned with procedure. They were so concerned because they took the view that if you get the procedures right, then what happens at the end will be a right outcome. We gave a lot of attention to our procedures, but first of all I'm going to tell you something about how the Commission of Inquiry came about, what it did, what it recommended, and then I'll address myself to the issue which is special for tonight of the common law meets the United Nations. Now, first of all, the Commission was established in May 2013. It was established when basically the members of the United Nations had had enough. They had created the office of a special rapporteur on North Korea. So many and so frequent and of such long standing were the complaints about grave human rights abuses in North Korea. But North Korea would not allow the special rapporteur access to their country. Originally, the special rapporteur was Professor Vitit Munterborn, a very distinguished professor of law in Thailand. And he couldn't get access, and subsequently he resigned and he was replaced by Mr. Marzuki Darusman, the former Attorney General of Indonesia. He likewise could not get access to North Korea. North Korea is a very closed place. It allows a certain number of tourists to come in at very expensive visa cost, but the tourists are very closely monitored. They can't go and talk, as tourists generally do, to local shopkeepers or local citizens. They're kept under very close surveillance, and if they endeavour to depart from the settled ways of their tour, they are apprehended, and in a number of cases they are shot. North Korea is a violent place with many public executions, and these reports were coming to the United Nations for a long while. There are whole libraries full of books on North Korea. North Korea is a source of fascination, but the fascination reveals a country which is a very cruel and unforgiving place. Because the special rapporteurs could not have access, and because North Korea, in undertaking what is called the Universal Periodic Review, to which every country in the Human Rights Council of the United Nations is now subject, and would not take any effective part in that review, and would not agree to a single one of the recommendations, 187 recommendations for improvement in their human rights record. A resolution was placed before the Human Rights Council to create a commission of inquiry. A commission of inquiry is ratcheting up the level of the investigation of the human rights situation in the country concerned. The Commission of Inquiry on North Korea is the first such Commission of Inquiry of the United Nations to be created without a vote. The President of the Human Rights Council, the Ambassador of Poland, thrice paused and asked if there was a request for a vote, but no request for a vote came forth. And that, I think, is another indication that the United Nations had had enough and it wanted to have this inquiry undertaken. 3 members were appointed to the investigation. One of them was Mr. Darusman himself, the Special Rapporteur. The other 2 were myself and Sonia Biserko. I, a former judge from Australia, was appointed to chair. Sonia Biserko is from Serbia. She is a person expert in the area of international human rights law, and particularly of genocide and crimes against humanity, two international crimes with which her own country, Serbia, has had recent and unhappy experience. And so we three were the commissioners, and we met for the first time on the 1st of July 2013. We met in the Palais Wilson, which is a very large chateau on the lake at Geneva, which was the original seat of the League of Nations. And it's named after President Woodrow Wilson, who had been the founding spirit of the League of Nations. But as you know, the League of Nations ultimately failed and never secured the participation as a member of the United States of America. And when the United Nations were established, the United Nations was established giving the United States of America and the great powers, including the Soviet Union, China, France, and the United Kingdom, a special status. In the Security Council, they are the permanent members. They are the P5, whose concurring vote is necessary for the legal validity under the Charter of any resolution of the Security Council. This is a matter that I will return to. When we first met, we concentrated for much of that first week on procedures so that we would get our procedures right for our investigation. And then we gathered around us a secretariat of 11 officials. They had been officers of the Office of the High Commissioner for Human Rights, who has her office in that building, the Palais Wilson. But they were severed from working for the High Commissioner so that they would be independent like the commissioners. They worked with us, for us, and under our direction. They came from different countries of the world. One, for example, came from Iran, and others came from Europe and Asia. One of them was a law graduate from Australia. And they worked with great dedication and under the direction of the three commissioners. The mandate we had from the Human Rights Council required us to investigate 9 headings which constituted the areas of human rights abuse which had been the subject of many reports to the Human Rights Council and which were identified in the resolution setting up the Commission. Number 1 was the issue of the detention camps in which, without due process of law, between 80,000 and 120,000 citizens of North Korea are detained. Often a person is put into the detention camp with 2 generations, a generation on each side, to remove the contagion from society of people who are thought to be hostile to the regime. A second item on the agenda was the issue of movement. Was there free movement within the country, as international human rights law promises? And we found that there was not free movement. There are restrictions on even leaving your village. You have to get permission to do so. It is a highly controlled society. The issue of access to information, which is essential in a democracy. Access to information is very strictly controlled. There is no access to the internet in North Korea, and access to radios and to television sets is very strictly controlled by the soldering of those sets so that you can only pick up the government-authorised stations. And possession of soap operas from South Korea, speaking the same language as the people of North Korea, are strictly prohibited and can lead to extremely severe punishment. Because, of course, in soap operas, in the background of the soap opera, you can see the television sets, the video recorders, the motor cars, the McDonald's stores, and all the other paraphernalia of a modern state. Another issue was food, something we tend to take for granted. But if a human being doesn't get food, they don't last for very long. And in the middle of the 1990s, there was a major famine in North Korea, partly the result of natural causes, but exacerbated by the lack of proper markets for the distribution and supply of food. This was a major calamity, and according to the materials we received from the World Food Programme and from the Food and Agricultural Programme of the United Nations, based on material given to them by North Korea, more than 1 million North Koreans perished in the Great Famine of the 1990s. That's 1 million plus in a population of 23 million. North Korea has approximately the same population as Australia. Just imagine if in our country in the 1990s 1 million people had perished. It would take Australia a century to overcome such a calamity. The issue of discrimination was also on our agenda. Discrimination against women. It's a highly patriarchal society. Discrimination against people who leave the society and go outside, generally to China, in order to try to get food for their families or to get ahead and get a better mode of life than the cruel regime in North Korea. And discrimination against people of religion. At the time of partition of the Korean Peninsula in 1945, breaking up the unity of the governance of the peninsula, which had lasted from about 640 right up to 1945. At that time, the population in the south who were identifying as Christian was about 23%. Likewise in the north it was about 23%. Many were Methodists. The Methodists missioned the Korean Peninsula. But in the north now, according to the figures given by the North Korean authorities, the Christian population in the north is 0.8%, so it's less than 1%, dropped from 23%. It's still about 23% in South Korea, but it's less than 1% in the north. And a question arose for us, is this because of the propaganda of the state that religion is the opiate of the people, something that Marx and Engels taught, or is it because there has been execution and killing of people on the grounds of religion? Certainly we had evidence placed before us. Very little picked up in the media. I don't quite know why this should be. Very little attention paid to this matter, but we certainly had evidence of people having been very severely punished and killed because they had on them Bibles or other paraphernalia of religion. But another and peculiar source of discrimination was the so-called Songbun system. The Songbun system was a system of a kind of class or caste, and in fact the original leader, supreme leader of North Korea, Kim Il-sung, the first of the Kims, had established a classification system of the whole population that classified people into about 50 sub-classifications. But basically they subdivided into three. The core class, who were the elite, who were favourable to the regime, the wavering class, who were not actually doing anything but were not thought to be reliable, and the hostile class. They were people who were often banished to arduous employments in the mines and elsewhere. They were people who could not be trusted. And this classification of people is very difficult to escape. If you're classified, it's very hard to escape it, and if you're classified hostile because your parents were thought to be hostile, access to education, to housing, being allowed to live in Pyongyang or access to food when that became essential to life was extremely difficult. So those issues were examined, plus the issue of abductions. The evidence demonstrated, and indeed North Korea actually acknowledged in a meeting between the President of South Korea and the President of North Korea back in the late 1990s, acknowledged that they had a state policy of seizing people who would be seen as useful to their economy. They did this at the end of the Korean War, as the North Korean forces were driven back into North Korea from South Korea, where they had invaded. They took with them 100,000, mostly men from South Korea, whom they thought would be useful. And most harrowing stories were given to us by spouses, mainly wives, telling of how they didn't even have time to say goodbye to their loved one, that not a day had passed but they thought of them and wished they could throw themselves on them and tell them how much they loved them. Occasionally, North Korea agrees to allow a small number of people in the North to make contact with their families in the South, for they're all one people who all speak the same language, but often these reunions, which only accommodate about 80 people, these reunions are cancelled at the last minute, as happened this year in respect of a family reunion that was due to take place. So these were the issues that we examined. On most of the issues we found very powerful evidence that reached the level that we thought would justify an investigation and a prosecution and a decision by a prosecutor to bring to accountability those who were responsible for these many wrongs. And we so concluded and reported in our report and recommended that a case should be presented to the International Criminal Court in The Hague for the purpose of rendering those who were responsible for these wrongs accountable. That recommendation enlivened a provision in the Rome Statute which establishes the International Criminal Court. For that court to have jurisdiction, one of two things must be present. Either the country concerned must be a member of the statute, a party to the statute, which North Korea is not, or the Security Council must refer the case to the International Criminal Court. And that brings us back to what I told you about the composition of the Security Council. It has the P5, the permanent five. They have what is called the veto, and unless their concurring vote is present, the resolution will not pass the Security Council. Our report was given to the Human Rights Council in March 2014. Not to put too fine a point on it, it created a sensation because it was written in a very different way to the way most reports of the commissions of inquiry of the United Nations were written. The Human Rights Council met the report with approbation. Only 6 countries voted against the adoption of the recommendations in the report. Those countries were China, a P5 member, the Russian Federation, a P5 member, Cuba, Venezuela, Vietnam, and Pakistan. They were the 6 who voted against. Most relevantly, China and the Russian Federation as P5 members. Then an unusual thing happened. The members of the Security Council, in advance of what would be the normal process of engagement of the Security Council's jurisdiction, called for a briefing to the members of the Security Council on what they saw as the urgent and important report on North Korea. The Security Council has already adopted resolutions on North Korea targeted at their nuclear program. North Korea has the 4th largest standing army in the world. This is with a population of 23 million. It's as if Australia had the 4th largest standing army in the world. It also has reportedly 20 nuclear warheads, and it also has developed a missile delivery system which is constantly being perfected and which they demonstrate by sending missiles towards Japan, their traditional enemy. And therefore, the Security Council members, led by France, a P5 member, but joined by the United States of America and Australia, which exceptionally was a member of the Security Council and still is, called for a briefing, an ARIA briefing. Mr. ARIA was a diplomat from Uruguay, and he had devised this idea that outside the formal meeting of the Security Council, where the veto might apply, you will have an opportunity for a briefing. We went to the briefing, the 3 commissioners and the Secretariat, in April 2014. It was not held in the beautiful chamber of the Security Council in New York. It was held in a very, very large room next door, which is basically a room of the General Assembly. And in that room, the room was packed with members of the General Assembly who turned up to see this, because this is a matter of deep concern to the world community. The 15 chairs of the members of the Security Council were in position in a horse-shaped design. 2 of those chairs were empty, the chair of the Russian Federation and the chair of the People's Republic of China. All of the other members of the Security Council turned up, and that was despite the reports that pressure was being applied to them by China not to attend, but everyone attended. And of the 13 who attended, 11 spoke in support of the report of the Commission of Inquiry, and of the 11 who spoke, 9 expressly endorsed the proposal that the case of North Korea should be referred to the International Criminal Court. What will now happen formally is that the report will go from the Human Rights Council to the General Assembly. It will probably arrive at the General Assembly in September this year, and from there it may be expected and hoped that it will be referred to the Security Council. Some people have said to me, well, you must be naive if you think that anything is going to happen in the Security Council. Did you not see those 2 empty chairs? But it's one thing not to turn up at a briefing. It's another thing to turn up and use a veto at a meeting, a formal meeting of the Security Council. The meeting, when it happens, will call forth the kind of skills that we saw quite recently on the part, I should say, of our Minister, Julie Bishop, in the meeting of the Security Council on the MH17 disaster, the downing of MH17. I think we Australians can take a degree of quiet pride in the fact that our government acted with resolution, with clarity, with determination, and the Minister was most effective in presenting the case that this was something above geopolitics that we just had to look at as a matter of human concern. The same can be said for North Korea. And I'm hoping for a second miracle. I'm hoping to suggest to Julie Bishop that sainthood comes with 2 miracles, and that she has already notched up one, and all she's got to do is notch up another. And I'm hoping that she will do just that. Now, I said I was going to talk about the United Nations meets the common law. I have to do this briefly because our time is short and I do want to have questions. The normal way a commission of inquiry operates is in the civil law way. The civil law way is the French, the European way. It's more cost-effective than the common law, it's more efficient, but it's more authoritarian and it's more secret. It tends to happen in secret, behind closed doors, and it gathers the evidence, and then writes a report, and that's it. The common law has been very peculiar since the beginning in its transparency. The English didn't like the idea of closed courts. They didn't like the idea of closed inquiries. They tend to have their inquiries in public. Just look at the inquiries that are going on at this moment in New South Wales, and you'll get my drift. They tend to be in public, they tend to take evidence in public, and that evidence is available to media and to the community. And the idea behind it is that those who gather evidence and who decide on evidence, whether they be judges or tribunals or inquiries, should always themselves be under scrutiny themselves. I never felt for a day that I was a judge, as I was for 34 years, that I was just doing my own thing. I was always under scrutiny, and that was right. And so we decided, we three, although their tradition, my other two colleagues, their tradition was the civil law tradition, because we couldn't get into North Korea and never expected to get into North Korea, we decided we would do it in the common law way. We would do it in the open. We would have public hearings. We would call witnesses in public if it was safe for them to give evidence in public. We would gather that testimony, and we would then get a transcript, and we would put the transcript online. It would be in the internet, and we'd put the hearings online. We would put the person online, so long as it was safe for them. Of the 250 people who came up immediately to give testimony, 80 fell in the category that we didn't have to see them in private. We saw the others in private, but we saw 80 in public. And in our public hearings in Seoul, in Tokyo, in London, and in Washington, D.C., we had witnesses in public. Some of them were experts, especially in Washington, people who were experts in North Korea, but most of them were just ordinary people telling extraordinary stories of dreadful suffering. And just like Holocaust museums, if ever you've been to a Holocaust museum, you'll know what I mean. It's told in such a low-key way. These remarkable stories of loss and grief and suffering, horrible stories of wrong, are just told in a low-key way, and it's all the more powerful for that. Also, we followed the common law principles, which probably the civil law also follows, of due process. We gave warning. We reached out to North Korea and said, we've negotiated that you will have diplomatic immunity if you send somebody down to South Korea, and you can take a position at the bar table, you can ask questions with the leave of the commission, and you can present your own evidence, and you can make submissions, all of which they refused to do. But it was given, and when our report was finished, we gave them a copy before it was published and said, this is what we're going to do. Tell us of anything you object to or anything you say is factually incorrect. They ignored it. We sent the report finally at the end of the process to the Supreme Leader, and we warned him that those who were responsible for the crimes against humanity, which we have identified, comma, including possibly yourself, comma, may be ultimately held accountable before an international tribunal to answer for it. And so these were the procedures we followed, and the procedures were fundamentally the procedures of our legal system. Procedures of openness, procedures of transparency, procedures of publicity, procedures of media, procedures of due process, procedures of natural justice. And I think that is going to make a change in the way the United Nations in the future conducts commissions of inquiry. On every page, virtually, of our report, which was written in the discursive manner of the way we write decisions. Not the minimalist way that they're written in the civil law tradition, the discursive way. On every page there are little quotes from the witnesses telling their extraordinary suffering, and with a vividness that we could never match, because this is a vividness born of the horrible experiences that ordinary people have had right through the report, just giving it a vividness and a dynamism that otherwise it would not have had. And so when I presented the report ultimately in New York to the Secretary General of the United Nations, Ban Ki-moon, himself a South Korean and therefore a person who has naturally to be very careful in the way these issues are handled, he said to me, "You told me at the beginning of this process that you were going to do this inquiry in a slightly different way." Well, you certainly did. And I think that is what, and I say this and I reach out to the young lawyers present, this is what lawyers trained in Australia can do. We can add value, we can do things in a slightly different way, and that slightly different way will almost inevitably be transparent and open and with due process, and that is just in our bones. It's inherent in the way we do public inquiries. So that's basically what I came to tell you. We'll now have a big round of applause, such as they have in the palace in Pyongyang, where the great leader comes, and after that we'll have some Q&A. Okay. No time for applause. We now have only time for some questions and answers. Okay. Anyone with any questions or comments? You don't have to agree with any of this. You can disagree, and this is still a free country.
Thank you, Michael. I would like to ask a question about the Japanese people who are aggrieved by also having family members removed. I was in Japan recently, and there was a lot of publicity given to the fact that about 15 years ago some people were returned, but there's still many dozens that are still in the North Korean peninsula. There was some hope in the Japanese press that in fact the new leader will rectify that grievance. Did you hear any evidence about that?
Yes, well, that was a major part of our inquiry in relation to abductions. The abduction issue mainly concerned South Koreans, but there were a number of Japanese citizens who were simply seized. People were sent in fishing boats, they landed in Japan, they would then seize citizens of Japan, something which outraged the Japanese sense of its own dignity and integrity of its borders. The numbers that were seized from Japan are a subject of a lot of contest. The government acknowledges 17 cases. The government is cautious to acknowledge every disappeared person because, of course, in every society people disappear, and they are not willing to pin North Korea unless it's very clearly a North Korean case. The Commission of Inquiry came to the conclusion the figure was probably closer to about 100. But whatever it is, it's an outrage, and it's like a piracy to go into another country, seize people, take them away. One case, a girl, Megumi, was going home from badminton practice at school. She was aged 12, I think, on her way home, due home at 7:30. Come 7:30, she didn't arrive. Come 8 o'clock, the parents began to get worried. 8:30, they're inquiring. No, she left the school. And 9:30, police are called. And eventually it was accepted and admitted in Japan that Megumi had been seized. Apparently, the best we can understand is she was taken there in order to teach security agents latest idiom in the Japanese language. And so this little girl is taken there, and her parents gave evidence before us of the devastation that they had suffered. I think partly as a result of our inquiry, Megumi was reported as dead. The North Koreans sent back what was said to be her bones for veneration, but they turned out to be dogs' bones when they were analysed for DNA, a very heartless thing to do. But then, after our report, North Korea admitted that Megumi had died, but that she had had a daughter, and arrangements were made in Mongolia for the parents to meet their granddaughter. And so they did meet their granddaughter. So one kindly thing has come out of our inquiry, but there are still a number of Japanese who are not accounted for, and the government of Japan has committed itself to finding what happened to each of its 17, and if it's serious, it'll go beyond the 17 and look at a number of other cases where there's a pretty strong case that it was a Japanese who was seized and abducted. Any other questions? Yes.
Do you feel a level of frustration that the outcome that you think will be appropriate will require this second miracle in terms of the way that the United Nations operates from now until the Security Council decision?
Well, of course, I do feel a sense of frustration. The life of a judge or of an inquirer is a frustrating life. But I have to say, on this occasion, I believe the United Nations has done everything it should have done in this case. And eventually it will meet the Security Council. Now, there are some people who say it's very wrong that the P5 have a special status. But the plain facts of the matter are that if at Dumbarton Oaks, in 1945, they had not reached agreement that, in particular, the United States of America and the Soviet Union had a special status, we would not have had a United Nations. And therefore, this was just part of the realpolitik of establishing the United Nations. The United Nations can be a very frustrating organisation to work with or for. But I believe in this case of North Korea, with a brilliant and hard-working secretariat, with good colleagues, independent-minded people, it worked exactly as it was intended, and it will ultimately work as it was intended in the Security Council. I take a bit of comfort from the MH17. There already is a resolution on North Korea dealing with nuclear. It doesn't require a new resolution. It just requires an amendment of the resolution that exists banning the supply of arms, because the United Nations, the P5, are against the nuclear weapons in North Korea. It's very dangerous for everybody. But I'm hoping that enough of the consensus will be found. China is the key. China does not want to have a common border with South Korea, if it can avoid it. It's quite happy with the buffer that is provided. On the other hand, China would not be happy with a state which executed the second or third most powerful man in the land, Jiang Song-tek, the uncle of the Supreme Leader, whose great sin appears to have been that he was urging that North Korea should go down the China path, and who was advocating greater trade and openness and so on with China. So China, in the history of the United Nations, has only used its veto 10 times. That compares with the Russian Federation, the Soviet Union, 350 times, the United States 250 times, Britain 150 times, France 80 times, China 10. China, that's not the Chinese way to go about international diplomacy. So I don't think it is starry-eyed to think that something may be able to be worked out. And certainly if you read the report of the Commission of Inquiry, which you can all see, you can get on the internet tonight, just Google North Korea Commission of Inquiry, you can see the witnesses. I mean, it is very interesting, it's powerful, and it speaks to humanity in the voices of the people who suffered. This is something new that we have now. We didn't have this in the past. So I'm not giving up. Remember Winston Churchill's motto, never give up, never give up, never give up. Any other questions? Yes.
You achieved this amazing process in 9 months,
well, less than.
When most of these things seem to take years to come to fruition. How did you manage it so quickly?
Well, the question is, how could you do all this in 9 months? Well, effectively, we only had 6 months, because remember, we met on the 1st of July, and we had to get it done by the end of the year so it could be translated into the 6 languages of the United Nations, 5 plus English. And the result was we had to actually do it in 6 months. And the answer to how we did it, well, basically we cut off evidence. You know, we had no problem getting evidence. We didn't get into North Korea, but we had no problem getting evidence. We advertised, we then became swamped with evidence. We got people wanting to see us. We had to cut it off and say, we'll get this because this will cover all of the heads of our inquiry. And we also suggested that a special field office should be created and should be based preferably in South Korea to continue the work of taking the testimonies. That in Cambodia proved extremely important, just to record what the people of the country have been through. And so the answer is we got through it by being very disciplined. You've got to be very disciplined in these things, and we were. But interestingly, when we finished our inquiry, as we were standing there in the Human Rights Council, who should come up to us but the ambassadors from the countries which had formerly been in the Soviet bloc. And they said to us, we know what you're talking about. Our cases were never as bad as North Korea, but we know this language, we know what you're talking about, and never think, if you don't get immediate responses, never think you've wasted your time, because what you have done is to record a snapshot of the suffering of the people of North Korea, and when in due course of time the cloud lifts from North Korea, they will know that the United Nations of the world did whatever could be done to bring to accountability those who are guilty of great wrongs against them. So that has its own value. Any questions on this side? Yes.
One understands China's empty seat due to the need for a buffer state and so on. But why Russia? What's Russia got to gain from?
In the case of Russia, I must say they were very correct in their dealings with us. When they didn't turn up at the Security Council, they sent their head of mission to come along and explain that they did not approve of country-specific inquiries. This was nothing against us, it was just that they don't approve of country-specific. That's a very formalistic approach. Once you've had a commission of inquiry and it's collected horrible evidence, to say, well, we wish you hadn't existed and we wish you hadn't had an inquiry and you didn't have all this horrible evidence, it's a very formalistic approach. But that was their position. Why would they be interested? Well, they have historical links. They now have no aid links. They have very few economic links. Their economic links relate mainly to the gathering of timber in the great forests. They take workers from North Korea up into the Russia nearby, and they gather timber, but very few economic links after the Soviet Union fell. But it's sentimental and it's historical, and it's deference to China. China has a very strong interest in this issue, and I think they're the explanations. But what we have to hope is that Russia's minimal actual interest, its concern for the unsafety of the region caused by a nuclear-armed country which got rid of its second highest official in a week, and publicly and executed, not public, they did it in private, but they executed him within 4 days. That instability is not good for Russia, and it's not good for China, and it's not good for the region, it's not good for the world. Any other questions up here? Yes.
Mr. Kirby, I was just wondering, in your personal opinion, with your experiences with North Korea, do you believe that North Korea will ever be able to integrate into normal global society?
Yes, I do. I'm old enough to remember in the 1980s, I used to go to meetings of the so-called Unrepresented Nations and Peoples Organisation, and it used to have people there from Timor-Leste. This was when, if you'd ask, are they going to be independent and have their own democratic society, be part of the international community, you probably would have said, and I would have said, no, that can't happen, won't happen. But it's happened. And similarly, others who were there were Estonia, Latvia, Lithuania, Azerbaijan, Georgia, and all these other countries. So I think the answer is never say never, because things change. It's important for me to tell you that we never adopted a stance of regime change. North Korea is a member of the United Nations. It's a member of the Charter. It's signed the Charter. It is a party to the Charter, which is a treaty. It also has signed a number of UN human rights treaties, though it doesn't do much to cooperate with the review of them. And therefore, our position was not, well, you've just got to get rid of this government and start again, or absorb into South Korea. Our position was, if you're going to be a member of the United Nations, there are certain common requirements of the United Nations. If you look at the preamble of the Charter, it says, effectively, this organisation is based on three great principles. International peace and security, which are the special responsibility of the Security Council. Universal human rights, which were drafted in the form of the Universal Declaration of Human Rights that I got as a boy at school in 1949. Eleanor Roosevelt's committee drafted the Universal Declaration. And justice for all people, which was the foundation for the removal of the colonial systems and is the basis of our search for an answer to global poverty, which is a kind of slavery of a third of humanity. So these are the principles of the United Nations, and somehow we have to hold North Korea to those principles. Now I see a far distant, beautiful blue colour, and I think the Dean Lacey, is going to throw me out very soon. But I do want to thank you all. I mean, North Korea is a long way away. A lot of people think it's a sort of weird but cuddly and unusual. It's led by a man with a bad haircut, but he has some strange friends. But really, why should we get involved? Well, we should get involved because of what we've known intuitively, but what we now cannot deny. The report of the Commission of Inquiry gives the detail, and in the voice of those who've suffered. And that's why it's important that our government should continue to stay the course and should take the matter to the Security Council. And if in the short run the Security Council, you see two or one country use the veto, then they will have to answer before the international community for doing that, and also they'll have to answer before the bar of history. But be sure that in due course of time, things will change in North Korea. That's the lesson of the last 50, 60, 70 years. Our species, I think, is genetically programmed to search for rationality, and a system of totalitarian government which worships a human being and denies millions of people food, basic food, and basic human rights is not rational, and it has to change to conform to United Nations human rights law.
Thank you, Michael. I spoke before about your compassion, your generosity and your commitment to social justice, and I think that was clearly evident in your presentation this evening. We may have lost you from the High Court, but the international community has gained you, and I think that is all to everybody's benefit. Now, earlier today we presented Michael with a gift from the university, which is a limited edition lino cut print by a South Australian artist that depicts the court precinct here in Victoria Square. Obviously we couldn't bring it into this room, but we will be couriering it to him in Sydney. But we do have a small gift that you don't need to share with Johan if you do not wish, Michael. You can eat it on the plane on the way home. But on behalf of everyone here at the University of South Australia and on behalf of my colleague, Adjunct Professor Ivan Shearer, we just want to thank you for being here today, for contributing to 3 events this afternoon, and it's always such a pleasure to have you.
Thanks, Herbie. Thanks.
Thank you. Hope you enjoyed that.
Thank you. Thanks, Alex. Okay.